Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call the morning's criminal docket. When you hear your name, please say present or here. Demetris Benson. Did I say your name correctly? Yes, sir. Jason Jones. Jason Jamal Jones. Jordan Manning. Here. Isaiah Rosser. David Shields. Here. Douglas English. Charles Hairston. Charles Hairston. Shiloh Scott. Thank you, Mr. Hairston. Daniel Admire. Courtney Atwood. Linda Bennett. Roderick Bradley. I see that Mr. Bradley is appearing on Zoom. Is that correct, Mr. Schmidt? I think I saw him. Okay. Roger Bridges. Cortez Cozy or Cossey. Cortez DeMonte Cozy. Trevor Glover. Here. Gerald Holmes. Ashley Holzhauser. Benjamin Carnes. Edgar Vasquez. Here. Charles Bell. Gavin Gonzalez. Here. Marty Hedden. Yes, Wesley Ball. Here. Lemmy Brandon. Joshua Brown. Carrie Criswell. Bailey Ditto. James Fontenot. Joshua Huffman. Kimberly King. Yes. Kip McNinch. Tu Nguyen. And Jeffrey Smith. All right, is there anyone in the courtroom your name's not been called and you expect to be on the docket? Your name, sir? John Ross. I do. I think I called it. Did I not call your name and check you off, Mr. Ross? Okay. John Robert Ross, for the record, is here. Who else? Say again. Harvey. Dorothy Harvey. Anyone else? Name was not called. All right, do we have any counsel that's ready? Who else? He beat you to it. He beat you to it. Barely.
Judge on Mr. Bell.
Hang on, real quick. Let me get to it. I'm going to call your case. We'll get you on the record. All right, this is Charles Kenneth Bell. Mr. Bell, if you'll come forward. And go that way. Will you put that right back up? All right, this is cause number CR 24-298, CR 25-1, State of Texas versus Charles Kenneth Bell. Mr. Wells, I show we're set for pretrial today. Go ahead.
Yeah, we just need a new date, Judge. We received a portal discovery yesterday and we're talking about it. So we just need a new date.
Is there any reason why we're just now getting discovery the day before pretrial? When I think we were indicted back in December.
Judge, I don't know. We've talked, but there's a lot of, witness information in this case that we're still talking about.
Well, I'm just concerned that we're just getting discovery the day before pretrial. We've already had arraignment. So do we have all that worked out?
We're fine as long as the court is.
Okay. All right, court will set. Mr. Bell, you want an additional pretrial, what you're saying, Mr. Wells?
Correct.
Any objection from the state?
No, Your Honor, thank you.
Is 30 days sufficient, Mr. Wells?
That's fine, Judge.
Are you available on Thursday, May 1st, Mr. Wells?
1 second.
While he's looking at that, Mr. Bell, have you signed your conditions of pretrial release? Have you met with Mr. West, the pretrial release officer?
Sure.
It's okay. Have you met with Mr. Todd West, the pretrial release officer? You have not? All right, so once you're done here today and you sign your notice of reset, I need you to meet with Mr. West. He'll be out in the hallway. He's with the pretrial release department. There will be conditions attached to your case that you must sign, okay?
Yes, sir.
Judge, May 1st is fine.
May 1st is good. All right, court sets Mr. Bell for pretrial on each case, May 1st. Make sure you sign those conditions and then you'll be free to go.
Thank you, Your Honor.
You're welcome. Mr. Gonzalez, Gavin Gonzalez?
Judge, that was at 9, correct?
9 a.m. All right, this is cause number CR 24-208, State versus Gavin Lane Gonzalez for pretrial. Go ahead, Mr. Wilson.
Judge would be asking for the same thing. The portal on Mr. Gonzalez got up yesterday, and I have some text messages that I have to get to the state for them to review that are part of the chain of the whole events that day and the day after.
Any announcement from the state?
Your Honor, we've been anticipating getting those text messages so we have a better picture of the case.
All right, court sets Mr. Gonzalez for an additional pretrial, May 1st. And Mr. Gonzalez, I need you to report to the pretrial release officer after you're through with Mr. Wilson.
Yes, sir.
Good. You can come over here and meet with Ms. Burns instead of Mr. West. Did he sign his notice of setting?
He has.
Okay, we come over here and meet with the probation department. You'll be free to go.
We excuse, Judge?
Yes, is that all, Mr. Wilson? Mr. Harrison, who would you like to call first? Ms. Scott, if you'll come forward, please. This is cause number CR 24-225, State of Texas versus Shiloh Darnell Scott for Docket call. Go ahead, Mr. Harrison.
Your Honor, we are going to request an additional pretrial hearing. We've got discovery we received additional supplemental discovery relatively recently. And I think there's one more set of discovery that I think we're outstanding. I spoke to Ms. Curry about it. We don't have medical records, and I think we do need those along with EMS run sheets, things of that nature. I've spoken with her. I think that shouldn't take too long to get, but I think we need one more pretrial.
All right. Any objection from the state?
No, Your Honor, thank you.
All right. You want May 1st or May 15th? I can give you April, but that's only about 2 or 3 weeks. If you're dealing with hospital records, it's probably gonna take longer than that.
Judge, the 15th, we're traveling out of state for federal court. Is there a different later date?
Later than May 15th?
Yes.
Do you think you could be done earlier, like April 17th?
Because it's medical records, I that's probably for a little bit more time.
May 27th?
That'd be fine, Judge.
The objection from the state to May.
No, Your Honor, thank you.
All right, court sets Ms. Scott for additional hearing and docket call on May 27th. When she signs her notice, she's free to go. Any other counsel ready?
Yes, Your Honor, this is on the Charles Hairston.
You're Mr. Hampton, correct?
Yes, Your Honor, I am.
All right, this is cause number CR 24-72, State of Texas versus Charles Hairston II. Mr. Hairston here. Charles Hairston. Finds that Mr. Hairston is not here, as he's been ordered to appear by the court. Mr. Hampton, I believe that you and your firm filed a motion to withdraw as counsel. Is that correct?
Yes, Your Honor, that is correct.
Did you send notice to your client?
Yes, Your Honor, we did back on December 3rd, 2024.
And did you have any discussions with him regarding your motion to withdraw?
I have not personally, but I think Mr. Carpenter may have had discussions with him. We did not receive any objection to our motion to withdraw. We originally were going to come back on January 9th. I believe that's when we originally set, but due to the weather, we were reset to come out today.
Ms. Tabraham, have you had any kind of contact from Mr. Hairston at all? All right, the court finding that Mr. Hairston received notice of today's hearing has failed to appear. The court will have his name called loudly distinctly 3 times in the courthouse. If no response, the court will issue a judgment not citing alias capias. Mr. Hampton, the court hereby grants your motion to withdraw as counsel.
Thank you, Your Honor.
I'll get an order signed and e-filed and sent back to you.
Thank you very much, Your Honor. Am I free to leave?
You're free to go. Yes, sir.
Thank you, Your Honor.
Great job, Mr. Hedden.
That's correct.
Marty Lynn Hedden. This is cause number CR 25-10, State versus Marty Lynn Hedden for pretrial. Go ahead, Mr. White.
Your Honor, I filed the 3 basic motions I do on every, and I don't believe there's any opposition. However, I would ask for another pretrial, as this is a situation that does have enhancements, and I would like to have about a month to be able to see whether or not I can be able to legitimately attack those enhancements.
Any objection from the state?
No, Your Honor.
Mr. White, are you available on May 1st?
I believe so.
All right, court sets Mr. Hedden for additional pretrial hearing May 1st at 9 a.m. Once he signs and gets his notice, it's free to go.
Your Honor, there's one additional matter to address.
Mr. Hedden,
With Mr. Hedden, as it turns out, when he was processed, the TRN information, the data actually was corrupted. He has been assigned a TRN number for this case, but he has to go back to the sheriff's department to complete it once again. My understanding is that he's supposed to meet with Detention Officer Elizabeth Sneed, and she knows exactly to use the old TRN number to not create more problems. So he's supposed to report on between Wednesday and Friday when she will be available to
is
do
that something that's already been worked out with Mr. White, Mr. Hedden, or are you asking me to?
My understanding is that it would have to be a court order to allow him to go into the back to be processed. So you may have to provide the paperwork as if he didn't have a TRN number assigned. The only difference here is it's already been assigned. Welcome to do that.
Your Honor, we were just checking out some things. I believe that we'll be able to go in, if not tomorrow, this week, because it needs to be there on a Wednesday, Thursday, or Friday. we're aware of that. I believe we do have an order on it. Mr. Heading does have another arrest that could be in front of this court. It has not been indicted. And I was wanting to make sure that there wasn't going to be any confusion between those two.
So I've already signed the TRN processing order.
On one of them, for sure, but like I said,
Well,
looking at the number itself, I wouldn't know which one. And there may not be a problem once we get him in with a number, be able to do anything that needed to be done on either one of the cases. What I'm saying is, I'm just wanting to make sure we don't go in there on one case and it not be the one that we really need to go in for. And I don't even know if that's the problem. I just bring it up.
you two want to get together and draft an order for me to sign that lays out exactly what it is the state wants, and so that the defense can make sure that that's exactly what it needs to do.
I'll be glad to help.
I mean, if I've already signed a TRN processing order, then that part's done. But in order to address what each one of you are asking for, I really need y'all to come up with an order, like lay it
Well,
out.
I tell you what. We can go in tomorrow, and if it doesn't work, we'll come back and get another. And that way I will know tomorrow, because he's gonna go in.
I would just suggest, I'm not ordering anything, but I've already ordered him to do the TRN. So I would just suggest that you and Mr. Hernandez get together and work out the logistics on that for Mr. Head, so that he understands and the sheriff's office understand what it is that needs to be accomplished, so that we can get the data that we need to report to the state. I'm assuming at this point it's just fingerprints.
Yes, that's my
what's-
understanding.
That's what's corrupted is the fingerprints.
That's correct, Your Honor. And actually, as I stated, Ms. Sneed knows exactly what's going on. She's aware of the case number and will track it. And that's why we asked that he speak with her directly. We may even put a call out tomorrow morning to her and let her know to expect him.
Okay,
Your Honor, we'll take care of that.
okay. I would suggest Mr. Hernandez send an email to Mr. White, CC, Ms. Sneed,
Mhm.
so that she's aware that when he's going to be coming, and we'll try to make this as painless as possible.
Thank you, sir.
All right, thank you, Mr. Head. Good luck to you, sir.
Thank you.
Ms. Harvey, will you raise your hand? Ms. Harvey, there you are. Keep it up. Ms. Tabraham's gonna come up here and speak with Ms. Tabraham. Mr. Schmidt,
Yes, sir.
are you ready on, sir?
Douglas English.
Mr. English, you'll come forward, sir.
That's under Mr. Manning's case.
All right, this is cause number CR 25-21, State of Texas versus Douglas English. We're set for pretrial. Court notes that Mr. Manning is representing Mr. English. It was set for today. I believe that after this case was set, Mr. Manning put in a vacation letter, so it wasn't reset. So court finds that Mr. Richard Schmidt, counsel, is standing in for Mr. Manning. Any announcements on pretrial today, Mr. Schmidt?
Judge, we'd ask just for an additional pretrial setting.
Any objection from the state?
No, Your Honor.
About April 17th, Mr. Schmidt. That's Mr. Manning's usual Thursday. Either the 10th or the 17th. If one of those is better.
I'll put him on some.
17th. All right, Mr. English, you're set for April 17th at 9 a.m. Once you sign your notice, you're free to go, sir. Daniel Admire. This is cause numbers CR 24-250 and CR 24-251, State of Texas versus Daniel Jack Admire pretrial. Go ahead, Mr.
We don't have any contested motions on file, Judge, ask for a docket call, so.
All right, court will set Mr. Admire for docket call. Mr. Schmidt, would April 15th be too soon?
Yes, sir.
That'd be too soon, 3 weeks. That's going to push him to the end of May 27th. Court sets Mr. Admire for docket call May 27th. That'll be at 9 a.m. And Mr. Admire, I need you to report to the probation officers for pretrial information after you sign your notice. Ms. Atwood. This is cause number CR 24-196, State of Texas versus Courtney Joe Atwood, and we're set for pretrial today.
Judge, I'm gonna ask for an additional pretrial setting on this avenue. Things I intend to.
Objection from the state.
No, Your Honor, thank you.
All right, court will reset Ms. Atwood for an additional pretrial hearing. Need as late as May 27th or something in April,
Something in April.
about April 8th or April 15th.
April 15th.
All right, court sets Ms. Atwood for pretrial April 15th at 9 a.m. Free to go. I'm sorry, that's also in cause number CR 24-196. Ms. Bennett. This is cause number CR 25-4, State of Texas versus Linda Diane Bennett for pretrial.
We have no contested motions, ask for a docket call, so.
All right, court sets Ms. Bennett for docket call May 27th. 9 a.m. After she signs, she's free to go.
Roderick Bradley. Regents through Zoom.
Mr. Bradley, can you see and hear me okay?
Yes, sir.
All right, I'm gonna call your case. Can you also see Mr. Schmidt, your attorney?
No, sir.
May have to move left or right on your screen. Move-
Oh, yes, sir. I can see him. I can see him.
Okay, excellent. All right, I'm gonna call your case, Mr. Bradley. This is cause number CR 24-163, State of Texas versus Roderick Morrell Bradley. And I show that we were set for plea today, but there may be some other announcement. Do me a favor, Mr. Schmidt, bring that microphone with you, just so it'll pick you up better.
Judge, we are set for a plea. We intend to go forward with the plea. I think there was some issues with Mr. Bradley. He's in Louisiana. We'd ask the court to entertain a reset for that plea, so we can get him in here and get it over with.
All right, how much time do you need?
Not much. April 15th, I believe, is your date.
All right, Mr. Bradley, court's gonna set you to appear in court to enter your plea. We're gonna do that on April 15th. Is that for a 9 AM plea? Mr. Sherman?
Yes, sir.
All right, that'll be at 9 AM, Mr. Bradley, so you'll need to make sure you leave early and get here on time, okay?
Okay, I sure appreciate it.
April 15th, 9 AM in court, okay?
All right,
All right, have a good day, sir.
you too.
Roger Bridges. Bridges, come forward.
With 60 days.
This is cause number CR 24-299, State of Texas versus Roger Neal Bridges. Pretrial, go ahead.
Judge, no contested, pretrial motion at this point, ask for a docket call.
There being no contested pretrial, court sets this matter for docket call May 27th at 9 AM. Here you go.
Trevor Glover.
Trevor Glover. This is cause number CR 25-8, State of Texas versus Trevor Cole Glover for pretrial.
And same announcement, no contested pretrial at this point. Ask for a call set.
All right, court sets Mr. Glover for docket call May 27th at 9 AM. Once he signs his notice, he's free to go.
Benjamin Carnes.
Benjamin Carnes. Case number CR 24-275 and CR 24-276. State of Texas versus Benjamin Colin Carnes for pretrial in each case. Go ahead, Mr. Chairman.
No contested pretrial, judge, ask for the docket call.
All right, court sets Mr. Carnes for for docket call on May 27th at 9 AM. Once he signs his notice of appearance, he's free to go.
Friday, 11 a.m. Tomorrow, let's visit with them. We'll go over here, if you have any issues, send me. Okay. From the evidence and that's great. Comes up, we got a little bit of time, we can reschedule, but I'm trying to get you knocked out that way. Yeah, so far. Ashley Holzhauser.
Ms. Holzhauser. This is cause numbers CR 24-263 and 264 and 265, 266, 267. State of Texas versus Ashley Nicole Holzhauser. I believe we're set for pretrial and all. Go ahead.
We are, Judge, and I know that the state was trying to procure additional discovery pertaining to restitution and some other issues. I don't believe they've received that in yet.
We have not yet. Your Honor.
But from that perspective, at this point, I guess we would just announce no contested pretrial, ask for doc call, and ask leave the court to file a late pretrial motion if it becomes necessary. I don't think it will.
Any objections?
No objection, Your Honor.
All right, then court will grant permission for the filing of late pretrial motions. Court says Ms. Holzhauser for docket call May 27th in each case. at 9 a.m. And once she signs, Mr. Schmidt, she is free to go.
Thanks. Oh, we wouldn't be able to read that.
That's all your practice.
Edgar Vasquez.
Mr. Vasquez. Come on up. This is cause number CR 24-292.
Good morning.
State of Texas versus Edgar Ariel Vasquez. For pretrial.
That's correct, Judge. No contested pretrial. We asked for that docket call setting.
This is also cause number CR 24-293.
Are you available?
Court finding there are no contested pretrial motions sets docket call May 27th at 9 a.m. Once Mr. Vasquez gets his notice of appearance, he's free to go.
We'll go do evidence on that date. Sign it here. That's right. That's it. I think I have a couple other. What about?
Mr. White, do you need more time? Are you ready on anyone? You need more time? You need more time, that's fine. I got others I can call. I just wanted to check with you first. Sure, no problem. All right, Mr. Benson, come on forward. This is cause number CR 24-125. State versus Demetrius Turner Benson. Mr. Benson, I see that you've been indicted and charged with the third-degree felony offense of possession of a controlled substance. Third-degree felony does carry a range of punishment, not less than 2 years in prison, up to a maximum of 10 years in prison, and a possible fine not to exceed $10,000 should you be convicted and sentenced on a case such as that. Do you intend to hire an attorney? Is that my understanding? Yes, sir. If I give you an additional 30 days or so, do you believe that'll give you enough time to hire an attorney? Yes, sir. All right, Mr. Benson, I'm going to reset your arraignment today. And I'm going to have you come back on May 1st. And that'll give you time to hire your attorney. Before you leave today, I do want you to meet with the court's pretrial release officer. Have you already done that?
Yes, sir.
You've met with Mr. West?
Yes, sir.
Okay, good. So once you sign this notice of setting, it'll have your new court date of May 1st on it. Make sure that when you do talk with this attorney, if they're aware of the court date, you can even show them a notice of setting, okay?
Yes, sir.
Mr. Benson, where you go. So I just want to tell you that if you intend to hire an attorney and you fail to do so, if it doesn't work out between you and the attorney that you plan on hiring, make sure that you continue to call other attorneys.
Yes,
A lot of times people are under the impression that, well, it didn't work out with this one attorney, so I didn't hire one. If it doesn't work out, then I expect you to call the next one and the next one and the next one until you find one that you're comfortable with, okay?
Yes, sir. Thank you so much.
We'll see you back on May 1st. Is Jason Jones here? Come on up, Mr. Jones. Oh, you did? Okay. I'm sorry, Mr. Daniels. Ms. Tabram's indicated that you're requesting court-appointed counsel, and so she's filling out your paperwork. So I'm sorry. Go ahead and have a seat, and I'll call you back in a moment.
Yes, sir.
Is Cortez Cossey or Cortez Cozy here? Mr. Rosser here, Isaiah Rosser. There he is. Let's see. We'll call you up just a moment. Mr. Shields? Right, this is a sanctions court hearing. David James Shields, cause number CR 22363. Let's see, Mr. Shields, you were placed on deferred adjudication for accident involving serious bodily injury. That was on May 16th of 2024. You're on probation until May 15th of 2030. It is deferred at this time. And should you be revoked, convicted, and sentenced, you're looking at a range of punishment from 2 years in prison to 10 years in prison. Are you trying to go to prison?
No, sir. No,
Well, the fact that you're standing here before me today says otherwise.
I understand. I plan on, by July, I should have my, all my community service taken care of, except for like 25 hours. I'm going to do first Monday for the next 4 months. And I want to try to get all my fines paid off within the next, hopefully the next year. And
Well, there's some more pressing business that I'm concerned about, and you know what it is. So
yes, sir.
don't tell me about all the stuff that you know is not going to bother me as much as what you know I'm reading. Tell me what I'm reading about right here.
I won't ever let it happen again.
Oh, tell me what it is.
It's, I use meth
Yeah.
and alcohol.
Multiple drug positives. And so you were ordered to do an evaluation. And that was ordered on August 27th. You're still not done.
No, sir. It's no excuse. I was out of the job for 3 months and I didn't have the money. I called him and we were going to reschedule, and I need to get it taken care of. It's been a rough winter. I'm going into summer. Work's going to pick up and I'll take care of everything. And no, I won't be positive again. Promise.
What I'm gonna do, Mr. Shields, I'm gonna order that you have the substance abuse evaluation completed before you come back to sanctions court. I'm gonna bring you back on May 1st. If it's not completed by May 1st,
Yes, sir.
might as well just bring your toothbrush. You're going to jail that day.
I understand.
Understand?
Yes, sir.
Not any more drug positives, any other violations. I'm just gonna tell the probation department that you're not a good candidate for deferred adjudication.
I understand.
Go to the next step.
Yes, sir. I understand.
Substance use evaluation. Good to go.
Thank you, sir.
Mr. Stevens, are you and Mr. Ross ready? Mr. Ross, come forward, please. This is cause number CR 24-224, State of Texas versus John Robert Ross. We're set for plea today. Are we going forward with a plea, Mr. Stevens?
Yes, Your Honor.
All right, Mr. Ross, sir, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Ross, your name is John Robert Ross, is that correct?
Junior.
Junior? And Mr. Ross, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Michael Stevens. Are you pleased with Mr. Stevens and work he's done as your attorney?
I'm okay with it.
Okay, is there anything that you feel like he should have done that he didn't do, that he had the control and power to do?
I'm not the attorney.
Speak up.
I wouldn't be able to answer that one. I'm not the attorney. I mean, I think he's done as best he could.
Okay, well, you said that you're okay with it. I just want to make sure, is there anything that you're not okay with?
I'm okay with it.
Okay. Mr. Stevens, do you believe that Mr. Ross is competent today?
Yes, Your Honor.
And have you explained to him his rights as they pertain to this case?
Yes, Your Honor.
And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Ross, you are charged by indictment with a third-degree felony offense of cruelty to non-livestock animals. That carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I see that there is a plea agreement in your case, which you intend to accept. And that recommendation from the state is that upon your plea of guilty for this crime, that the court consider the evidence, convict you of the offense, assess your punishment today at 7 years confinement in prison. But the state is recommending that the court suspend that sentence and place you on community supervision for a period of 3 years. In addition to that, you would have a $1,500 fine, court costs of $290, and reimbursement fees of $35. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, Mr. Ross, how do you plead to cruelty to non-livestock animals, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
I didn't consider it cruelty, but the state considers it cruelty, so I'm accepting it.
Okay. The allegation that they allege is true, is that correct? What they indicted you for, you did in fact commit that behavior and that action, is that correct?
There was a situation, and I reacted by it. Something wasn't being done, it got thrown on me to take care of it. And I basically got cornered over it. So yes, I took care of it in probably a manner that the court does not like. But the dog is off the road. I'm not going to be threatened for my life for that dog ripping bumpers loose anymore or anything like that.
Do you feel, Mr. Ross, that anyone's threatened you, forced you, pressured you, or otherwise made you feel like you had to plead guilty to a crime?
I just have to accept it.
That's not the question I asked. I want you to answer the question that I asked. Do you feel like anyone has pressured you, threatened you, or made you feel like you had to plead guilty to this offense?
No, sir.
No? Okay. All right, the court will accept the defendant's plea of guilt at this time. Mr. Stevens, any objection to the stipulation of evidence offered to support the plea?
No, Your Honor.
All right, the stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Your
All right, the court will consider the evidence.
Okay. All right, I'm good.
All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense for court will follow the plea agreement. Court convicts John Robert Ross Jr. of cruelty to a non-livestock animal, a third-degree felony. Court assesses punishment at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspends that sentence today on the recommendation of the DA's office and places Mr. Ross on 3 years community supervision. Orders Mr. Ross to pay a $1,500 fine, $290 in court costs, and $35 in reimbursement fees. Mr. Ross, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. And have you come forward to be fingerprinted. After that, you'll meet with the probation officers. Right, you ready? Yeah. Who would you like to call first?
We call Mr. Ball.
Wesley J. Ball. This is cause number CR 23-232 for docket call. Go ahead, Mr. White.
Your Honor, it's court will call just real quick. We were trying to get an expert hired, which, and have that expert look at all of the discovery along with me. We've done that. State and I are still in discussions. I feel like that if we could have one more date, and I think the state will join me in that, we will have an answer. And I would suggest we just set it for a final docket call, because if we're not good on that date, we're gonna have to set it for trial.
Any objection from the state?
No, Your Honor, thank you.
You want that May 1st date, Mr. White?
Excuse me, Your Honor, I'm gonna look at my schedule real quickly. Seems like I've got something said. Yes, sir, we can do May 1st in the morning.
All right, court sets Mr. Ball then for final docket call. May 1st at 9 a.m. Once Mr. Ball signs his notice of appearance, then I need him to meet with the probation officers before he goes. Who's like next?
Ms. King.
Kimberly Madeline King, CR 24-278. Except for pretrial today, Mr. White.
Yes, sir. Your Honor, we don't have any contested pretrial motions. We'll abide by the court's standing order. Ask the court to move this over to docket call.
All right, Mr. White, do you need more than 30 days? I've got some settings in April, about 3 weeks or so. Would that be enough time or do you need more time?
I'm gonna need more time on this one, Judge.
You will? You said?
Yes, sir.
All right, court sets Ms. King then for docket call May 1st. 9 a.m. Here you go.
Fine.
Who's next?
Let's do Mr. McNinch.
Mr. McNinch. This is cause number CR 24-217. McNinch is set for docket call. Go ahead, Mr. White.
Your Honor, the state has extended an offer to us. I need to speak further with Mr. McNinch about that offer. If the state doesn't object, I'd ask for an additional docket call.
No objection, Your Honor.
All right, there being no objection. Can we do that in April, Mr. White?
I'm gonna have a little bit of a tough time with April, Your Honor, right now, because I am set for trial downstairs. I don't know if that'll go or not, but if it does, that's gonna.
All right, court sets Mr. McNinch for docket call May 1st.
Let's do Mr. Brandon.
Let me, Brandon, CR 21-206.
Your Honor, we're set for pretrial, Mr. Brandon. There were some videos on this matter, and in particular, there was one. We were having a real hard time with it, and Miss Abney went above and beyond trying to help us, but we just could not get it to play. We finally got it to play. I have not had a chance to review that and then review it in light of the other information as well in this matter. I'm going to need another pretrial.
Any objection from the state?
No objection, Your Honor.
All right, court sets Mr. Brandon for an additional pretrial May 1st. Just a second, Mr. Brandon. All right, Mr. Brandon, you're delinquent in your pretrial release fees by $20. Can you pay that today?
Yes, sir.
Okay, so I just asked that you go over and go over to the pretrial department, probation department, pay the $20, and then we'll see you back on May 1st.
Yes, sir.
Yes, just to ask, can he?
Yeah, come over here and see Ms. Burns and she can tell you where to go. And when Mr. Brandon leaves, he'll leave out the back way here. So if you want to, you can stay in the hallway and he'll be right out there. If you sit in here, wait on him, you're not gonna see him again, so. Who's next?
Mr. Smith.
Jeffrey Allen Smith. This is cause number CR 24-176. And Mr. Smith is up for docket call today. Go ahead, Mr. White.
Your Honor, I think the state is going to join. We're going to ask the court to set this for a plea on May the 1st.
Any objection?
No objection.
All right, court sets Mr. Smith for plea before the court May 1st. Was that 9 a.m. plea, Mr. White?
Yes, sir.
Who's next?
We do Mr. Fontenot.
Mr. Fontenot. This is cause number CR 24-258, State of Texas versus James Owen Fontenot. We're set for pretrial. Go ahead, Mr. White.
Your Honor, we don't have any pretrial motions that are contested. We abide by the court's standing order. Ask the court to move this over to docket call.
All right, court sets Mr. Fontenot for docket call May 1st at 9 a.m. Mr. Fontenot, I show that you're delinquent on your pretrial release fees by $70. Is that something you can pay today?
Yes, sir.
Can? All right, so when you leave today, do you know where the probation department is?
Across the street.
Across the street, yes, sir. You'll go over there and pay your $70 today,
Okay.
all right? Who's next, Mr. White?
Mr. Huffman.
Joshua Huffman. All right, this is cause number CR 24-165, State of Texas versus Joshua Stephen Huffman for pretrial.
Your Honor, we don't have any contested motions. We will abide by the court standing order directed. Ask the court to move this over to docket call.
All right, court sets Mr. Huffman for docket call May 1st at 9 a.m. Once he signs, he's free to go, Mr. White. So.
Thanks, sir.
Who's next?
Mr. Criswell.
Mr. Criswell. Cause number CR 24-301, State of Texas versus Carrie Lynn Criswell for pretrial. Go ahead, Mr. White.
Your Honor, we don't have any contested motions. Ask the court to move this over to docket call. We abide by the court standing order.
All right, court says Mr. Criswell for docket call May 1st at 9 a.m. Once he signs, gets his notice, he's free to go. Joshua Neal Brown. It's cause number CR 24-255, We are set for pretrial, Mr. White.
Your Honor, feel like a broken record. We don't have any, tested motions. Ask the court to move this over to docket call.
All right, court sets Mr. Brown for a docket call May 1st, 9 a.m. Once he signs his notice, he's free to go.
Mr. Brown,
Good, Your Honor, free to go.
just real quickly, Your Honor, I've got a couple of pleas, but I've also got a couple of matters. One of them is Obed Minjasu.
Is that on this afternoon's docket?
I believe it would be, Your Honor, but he's in Dallas County.
So on the afternoon docket, cause number CR 24143, State versus Obed Baru Mingastu. Court will reset that pretrial hearing. And for a status of custody, we'll reset that to May 1st. And then your other one this afternoon is Dallas Vigil, is that correct?
Yes, sir. He's,
In Tarrant County?
yes, sir, he is. I believe he discharges his sentence there mid-April. So if you want to put that one on that, since he's gonna be in custody here, court wants to put that sometime at the end of April, I'll make that one work.
All right, court, well, we'll just put them on May 1st. Court sets cause number CR 21251, State versus Dallas Anthony Vigil. We'll do a status of custody May 1st.
And Your Honor, may I approach?
Just one second. Mr. White, Mr. White, are you working on Rayleigh Ditto?
We've got those ready to go, Your Honor, but I would ask the court to take up Mr. Smith.
Is Ditto your last case?
This will be,
Mr. Wayne, okay. Mr. Schmidt, who do you want?
Jason Jones.
Mr. Jones? Right, this is clause number CR 21-297, motion to adjudicate State versus Jason Jamal Jones. Court this morning has found Mr. Jones to be indigent for purposes of the Sixth Amendment, and the court has appointed the Honorable Richard Schmidt as counsel. Mr. Schmidt, I will reset today's motion to adjudicate hearing to April 29th. That'll be the first setting, April 29th at 9 a.m. all you have, Mr. Smith. Mr. Manning? All right, this is sanctions court hearing for Mr. Jordan Manning. And cause number CR 24-247. Mr. Manning, you are currently on 4-year deferred adjudication, community supervision term. Looks like you're set to expire in 2028. You've been on it since October 31st of last year. You're here in sanctions court today because the probation department has an opinion that you're not taking your probation seriously, and that you've never worked any community supervision, and you're delinquent on your fees. You're assessed 400 hours of community service and you're already 40 hours behind. And you're delinquent $165 in your fees.
Yes, sir.
What would you say to that?
It's hard to maintain 400 hours with a full-time job, Your Honor. And I have too many bills. Well, not too many, but I have a lot of bills on my plate.
What hours do you work?
Monday through Friday, it depends on the hours of the day.
You work Saturday and Sunday?
Not all the time, sometimes.
So Saturdays and Sundays that you're not working, you should be doing what?
Community service.
And it's not that hard. That's talking about one Saturday a month. One.
Yes, sir.
You got 3 to 4, you got at least 4 Saturdays a month. You realize that you're looking at up to 20 years in prison?
Yes, sir.
Really? Have you really thought about that?
Yes, sir.
Where you wouldn't sacrifice one Saturday a month to make sure that you're in compliance versus the risk of coming back to court looking at 20 years in prison? I mean, have you really stopped? I mean, how old are you?
23.
23? And Mr. Manning, I mean, you signed up to do the deferred. You knew what was required of you. You read the conditions before you signed. So it's not like this is a shock or a surprise to you, right?
No, sir.
So you're either going to do it or you're not going to do it. That's really all we're waiting to see.
Yes, sir, Your Honor.
If you're not going to do it, that's fine. I mean, that's your choice. If you don't want to do it, that's fine. And then I get to make the choice of what happens to you.
Yes, sir.
Do you want me to control how you live your life?
No, sir.
Do you want me to decide whether you go to prison or not?
No, sir.
You want these gentlemen over here at this table to decide whether or not they should prosecute you and try to put you in prison?
No, sir.
I mean, in your opinion, who's the best person to be deciding how to live your life?
Myself.
Okay. And so these decisions that you're making now, we've been letting you make these decisions.
Yes, sir.
But pretty soon, if you keep it up, you won't be making these decisions anymore.
Sir.
Okay. So I'm going to impress upon you how important it is. And I'm going to do it this way. I'm going to sanction you to 3 days in jail for your noncompliance. I'm going to show you how you have to make time to get things done. Like your community supervision, paying your bills. We all got bills. We all got responsibilities. You've got all that, and you've got probation responsibilities.
Yes, sir.
And you better start setting a priority in your life. All your money, you should be, besides making sure that you're fed and sheltered and all that, any other money better be going to the probation and your court costs, because that's going to decide whether or not you're sitting in prison or sitting at work or sitting at your house. You understand?
Sure.
It would be sad to have a 23-year-old go to prison for 20 years because he didn't take probation seriously. Come out as a 43-year-old man and lose the prime of your life. Okay? So I'm going to give you 3 days in jail. Okay?
Can I get a number from my girlfriend?
Don't worry about it. No, I'm not gonna send you to jail right now. Okay, I want you to hear me out. I'm gonna give you 3 days in jail.
Alright.
But I'm gonna give you an opportunity to avoid those 3 days
Oh, okay.
by doing these things, okay? 15 hours of community service before you come back to Florida. 2 Saturdays, you knock that out, okay? Or 2 Sundays, however you wanna do it. 1 weekend, 1 Saturday, 1 Sunday. You gotta pay $75 to probation. And we're gonna divide that up. 10 of that's gonna go towards your delinquent fees, and then $50 towards your court costs. Okay, so that's $125.
Sure.
15 hours of community service. And you gotta have that done. I'm gonna have you come back to court on May 1st. And you gotta have those things done before you come back to court,
Sure.
okay? That is May 1st is a Thursday. So I want it done the week before, that last week of April. I want that done. Okay?
Sure.
So I don't want you to walk in and say, oh, I'm paying it today. Or, oh, hey, I'm gonna do my hours today. That'd be too late. If you do that, then I'm just gonna give you the 3 days in jail.
Sure.
And then guess what? We're gonna do it again and again and again and again until you realize, hey, this is very serious.
Sure.
Okay? So I'm gonna have you come back on May 1st. You're sanctioned to do 15 hours community service, $75 to probation, $50 to your court costs. For every one of those that you don't do is a day in jail. So if you pay, don't do the probation, 1 day in jail. If you do the probation and you don't pay, 2 days in jail. If you don't do any of it, 3 days in jail.
Sure.
Make sense? We clear?
Yes, sir.
All right. Mr. Rosser? All right, this is sanctions court hearing for Isaiah Rosser, cause number CR 21239. All right, Mr. Rosser. I've got serious concerns for you. I've got serious concerns for you. Had you do the UA today and they tell me that you're positive for cocaine. It's okay. You don't tell, you know what, it'd be better if you don't say anything. It'd be better for you just to listen. They tell me you're positive for cocaine, that you've denied that. We're gonna send that off to get a lab to confirm our field test. Okay? I'm just gonna tell you, it doesn't look good for you. That comes back confirmed. Next time you're standing here, you won't be looking that sharp. You're gonna be in an orange jumpsuit and handcuffs. And you're looking up to 20 years in prison for drugs. Been on deferred since 2022. And you haven't done what you're supposed to do. Missing sanctions court, not paying, not doing community service. Quite frankly, you're not doing a damn thing I want you to do. You're doing what you want to do. So it's all right. No. Just stay quiet. I'm gonna see you back on May 1st. I'll tell you what, just come back on May 1st. And I'll have that drug test back and we'll see where we go from there. All right. Go. Mr. White, you ready?
Yes.
Who would you like to call first?
Mr. Wynn's fine.
Mr. Wynn,
Your Honor, I have those.
this is cause number CR 24144, State of Texas versus 2U Wynn.
Sent to plead them in December, so I just went back and changed the date. It was just one that I was missed as far as getting stuff.
Mr. Wynn, you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you'll lower your. I didn't tell you this, Grisham, CR 24-144. All right, Mr. Wynn. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work you've done as your attorney?
Yes.
Do you have any questions about anything involved in your plea agreement today?
No, Your Honor.
Mr. White, do you believe Mr. Nguyen is competent today and that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do, Your Honor.
And you've explained to him his rights as they relate to this case, including the advantages and disadvantages of a deferred adjudication plea.
Your Honor, I have. I believe he's waived those rights, as I said, knowingly, intelligently, and voluntarily, and we went over advantages and disadvantages of entering into such a plea. Most notably, if he violates any term or condition, the court will hold a hearing. If the court finds by preponderance of the evidence that he did in fact violate his probation, the court can sentence him up to 20 years in state penitentiary and a $10,000 fine. I'm satisfied that he understands the gravity of the agreement he entered into today.
Thank you, Mr. White. All right, Mr. Nguyen, as Mr. White has accurately stated, you are charged with a second-degree felony offense of possession of a controlled substance between 4 grams and 200 grams. That does carry a range of punishment of not less than 2 years in prison up to a maximum 20 years in prison and a fine not to exceed $10,000. I see that the plea agreement and recommendation in your case from the DA's office is upon your plea of guilt, they're asking the court to consider the evidence, but not convict you, but rather to place you on deferred adjudication for a period of 4 years, and also a $1,500 fine, $180 in restitution, $290 in court costs, $35 in reimbursement fees. In addition, the state is agreeing to dispose of some unfiled cases. Look like possession of marijuana and 3 separate, possibly 1, 2, 3, 4 allegations of possession of controlled substance offenses. Mr. Nguyen, is that your understanding of the plea agreement today?
Yes.
All right, understanding the plea agreement and the range of punishment, I plead to possession of a controlled substance of penalty group 1, greater than 4 grams, less than 200 grams.
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Not guilty.
And Mr. Nguyen, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No, sir.
All right, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will consider the evidence. All right, court, having considered the evidence, finds enough evidence to convict the defendant of this offense. The court this day will follow the plea agreement and recommendation of the state. Court hereby defers the finding of guilt on the second-degree felony offense of possession of a controlled substance. Penalty group 1 greater than 4 grams, less than 200 grams. The court, in deferring finding of guilt, places Mr. Nguyen on 4 years community supervision. Orders him to pay a $1,500 fine, $290 in court costs, $35 in reimbursement fees, and $180 in restitution. Court finds the DA's office is agreeing to consider under section 1245 Texas Penal Code unfiled DA cause numbers, DA 2023-993 possession of controlled substance, DA 2023-997 possession of marijuana, DA 2023-995 possession of controlled substance, and DA 2023-996 possession of controlled substance. Mr. Nguyen, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of this sentence. I'm going to have you come forward to be fingerprinted with Deputy Martinez. Second page of that judgment before you take it. Mark off the appeal and switch. You ready on ditto? Say you sign them out, ready.
Yes, Your Honor, those should have been all, I have a print off that those were digital.
These are electronic.
Yeah, I do have it.
Rayleigh Mark ditto, clause number CR 24257.
Oh, okay.
I didn't know this.
Well,
That when I got in the or that is it electronic or is it?
so they are electronic, but I guess, so just, wet signature on this?
Yeah, he and I signed those bills.
Okay.
Had him sworn on that. Sorry, Your Honor, I didn't.
Yeah, we're trying to go to digital please from here on out on everything.
Yes, sir, I will make sure we do that.
All right, Mr. Ditto, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Your name is Rayleigh Mark Ditto, is that correct?
Yes, sir.
And Mr. Ditto, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done as your attorney?
Yes, sir.
Do you have any questions about your plea agreement or anything else?
No, sir.
Mr. White, do you believe Mr. Ditto to be competent? And if so, have you explained to him his rights regarding this case, including the advantages and disadvantages of a deferred adjudication plea?
Yes, sir, I have. I believe that waive the rights knowingly, intelligently, and voluntarily. And I've explained to him the advantages and disadvantages of entering into such a plea. Most notably, if he violates any term or condition of his probation, court will hold a hearing to determine whether or not he did so. And if the court finds that he did so by preponderance of the evidence, the court can sentence him up to 10 years in the state penitentiary as well as up to a $10,000 fine.
Thank you, Mr. White. Mr. Ditto, having been charged with a third-degree felony offense of possession of a controlled substance, penalty group 1 greater than 1 gram, less than 4 grams by indictment, that does carry a range of punishment of not less than 2 years in prison up to a maximum of 10 years in prison, and a fine not to exceed $10,000. Plea agreement in this case is upon your plea of guilt. The state's recommending that the court defer a finding of guilt and place you on 3 years community supervision with a $1,500 fine, plus court costs, reimbursement fees, and restitution. Is that your understanding of the plea agreement, sir? All right, Mr. Ditto, how do you plead to possession of a controlled substance of penalty group 1 greater than 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No, sir.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial conclusion. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense? All right, court will consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense. Court will follow the plea agreement. The court defers the finding of guilt, places Mr. Ditto on 3 years community supervision, orders him to pay a $1,500 fine, $180 of restitution, $35 reimbursement fees, and $290 in court costs. Mr. Ditto, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the probation bailiff, and then after that, you will meet with the probation officers, okay?
Have the other form that she figured out. Patty. It's the ditto form we have.
Do we have a fingerprint from? Well, that's because it's digital, so that's. That was a picture. Oh, yeah, Mr. White. Yes. This is cause number CR 24-55, State of Texas versus Gerald Alexander Holmes. Motion to revoke. Court finds that Mr. Holmes is qualified for appointment of attorney under the Sixth Amendment indigency standards. Court has appointed the Honorable Richard Schmidt as counsel for Mr. Holmes. Mr. Schmidt, I will reset this case today for our next motion to adjudicate revoke docket, which would be April, not the next one, but April 29th.
Yeah, but I already got no camera. You keep saying it. I'm telling you this, you may very well have it, but I doubt it. I will sort it out. I will get you the bottom. I still have those things pending. I moved the driver's seats and all. Is he free to go?
He's free to go. See you back on April 29th.
Email, like you're supposed to. You should have my email address. Send it.
Thanks, sir.
All right, I believe that concludes this morning's criminal docket. Court will stand in recess until 1:30.